This program was brought to you by the Illinois State Bar Association. All copyrights are owned by the ISBA. If you have any questions regarding the content of this presentation, please contact the presenters at isba.fastcle.com/questions.
And Andrew has spoken for us before, and he speaks on the complex issues, including how you use the Uniform Fraudulent Transfer Act to obtain assets that are gone and bring them back. And how you can, and he'll actually, I hope, speak a little bit about how you can use the attorney's fees provision of the IMDMA to get paid for doing just that. So this is yet another discipline that intersects with family law that I want to know more about. And so his uncorrect bio is in the materials, but his firm name is actually on the PowerPoint. So, Andrew R. Schwartz.
Thank you. Good afternoon, everybody. My presentation today, it's called, this time around, it's called The Secret Stash. Previously, we've presented some of the same materials under a title that may be a little bit more familiar to matrimonial attorneys, which is called Beyond Dissipation. And the topic today is going to deal with the Illinois Uniform Fraudulent Transfer Act and how matrimonial attorneys can use that statute to try and amp up their clients' recoveries in cases where you've got a litigant on the other side who is not playing fair. And I'll start with the bad news. We all know, and the drafters of the Marriage and Dissolution of Marriage Act all knew, that divorce takes rational people who may be very nice in their regular lives and turns them into irrational people. I have a fairly good friend who is a matrimonial attorney here in town who I had coffee with a few years back, probably more than a few years. And he told me, he came back from court, and I met him for lunch or coffee or something, and he says, I practice 3 areas of law. I do corporate work, I do mental health law, and I do domestic relations work. I like corporate work because you're dealing with money, and that's interesting. I like mental health work because you're dealing with crazy people, and they're fun. When it comes to family law, it's not so much fun because then you're dealing with crazy people's money. The Illinois law, or the legislature, as we heard from Lane's very nice presentation just a few moments ago, wisely changed the law to remove marital misconduct from property distribution, also from maintenance. The problem is that has not stopped divorcing parties from fighting over assets, and that has not stopped divorcing parties from behaving badly. And a lot of the time what you will see is spouses who are in control of more assets than the other spouses, sometimes the husband, sometimes the wife, who will try to conceal assets, conceal their income, and do other antisocial things to try and edge the financially weaker spouse. The good news is that your ordinary Illinois legal procedures that you can find in the Code of Civil Procedure, again going back to Lane's fine presentation from this morning, gives you a lot of abilities to seek out information that will help you find where the assets are. You've got formal discovery, you've got discovery sanctions under Rule 219 of the Supreme Court rules. If you've got somebody who's being really recalcitrant and not disclosing his or her assets, you can always do what I like to call the classical matrimonial attorney strategy. File a petition for rule, move to hold him in contempt, get a judge to order that, Mr. or Miss Litigant, unless you do what you're supposed to do. I'm going to enter an order that's going to do something really, really bad to you. I'm going to fine you. I'm going to put you in prison, and I'm going to make your life miserable until you comply. You can file a dissipation claim if you see that you've got a spouse who is financially stronger who has moved assets to a third person outside of the marriage. Dissipation, as you all know, allows you to try and adjust the marital estate to correct for the dissipation. My area of expertise is the Uniform Fraudulent Transfer Act. I've got it identified as the UFTA, which are its initials. You'll see me sometimes refer to it as the IUFTA, which is nothing more than the Illinois Uniform Fraudulent Transfer Act. We are one of 43 different jurisdictions around this country that have enacted some version of the Model Uniform Fraudulent Transfer Act. Ours is particularly pure because we adopted it with no comments, and there were no changes. It was just adopted lock, stock, and barrel. I believe it was in 1989, and it became effective in 1990. Let's start with a scenario. You've got a husband gives all his stock and his business to the girlfriend just before he files for divorce. You know he's done this because now he wants to say, well, there's no stock in my business that's in the marital estate at the time the divorce was filed, and now the wife has no rights in marital estate rights in that asset. What do? You file a dissipation claim. And as I pointed out before, it allows the court to adjust the distribution of the marital estate to compensate for the dissipation. Same scenario, except what if the stock in this guy's closely held business was the only asset of the marriage or the only substantial asset of the marriage? Now you've got a situation where a judge cannot effectively award a dissipation award, because even if you do, you are still not going to compensate the wife adequately for the loss of the stock. What you do, and this is what we do in our firm, is we would file a claim to unwind the transfer of the stock from the husband to the husband's girlfriend. This is sometimes called an avoidance action. You'll see it called a UFTA complaint. You'll see it as a fraudulent transfer complaint. Under the prior law, it used to be called a Fraudulent Conveyance Act claim. It's the same thing. Essentially what we're doing is we're saying, you gave away an asset when you knew you had this obligation you had to pay, bring it back. The UFTA, as I said, is a statute that can be found. The materials that I printed out, that's after the slides, go into detail about the statutory site numbers and some of the cases that are on point. I'm not going to get into those during the discussion, but in essence, what I'd like to talk about is how matrimonial attorneys can use the UFTA offensively, defensively, and for self-protection. You want to protect your client's interest? You really ought to consider protecting your own interests as well, because just a show of hands, how many of us have had clients who come in and say, gee, I know I'm going to get divorced. What can I do to kind of level or to tilt the playing field in my favor? Little divorce planning, and as good attorneys, you're thinking to yourself, well, let's see, there's estate planning, and there's asset protection, and unless you're really comfortable swimming in those waters, you want to be very, very, very careful, because you can get yourself into trouble, and you can find yourself on the other side of a fraudulent transfer claim if you're not. Let's talk about some more examples of fraudulent transfers. We've got a wife who gives a $1 million gift to the children from her first husband after her second husband files for divorce. We've got the husband's fire sale to his girlfriend after the bank calls a note. We've got the wife's $1 million mortgage to her father securing the $10 debt. We've got an overly generous dividend plan by the husband's failing company, or even potentially by a company that isn't necessarily failing when the husband is contemplating divorce or is involved in a divorce. And the common theme through all of these examples is each of these examples shows a dissipation or a draining away of money. You are taking money out of what would otherwise be the marital estate, and you are making it unavailable. Let's talk now about what a fraudulent transfer is. And a fraudulent transfer refers to a voluntary depletion of net worth that frustrates the claims of creditors. Now, I will say this with using the word voluntary, that's mostly what you see in the case law. There is a rogue federal case that talked about an involuntary transfer being a fraudulent transfer. That's a little bit on the complex side. I don't know that we want to get into that too much, but for the most part, what you're going to see are voluntary transfers. This type of dissipation is considered a fraud on the creditors of the debtor. And a creditor, as we're going to see, is a broadly defined term. We'll get into that in a bit. There's a wonderful case that I've got some material got cited in materials. It's called Falcon versus Thomas. That says one must be just before he can be generous. This was actually an older case. It was I think it was from the 1920s. It was an Illinois Supreme Court case, and it's been echoed a few times subsequently to that. But it kind of says it much more eloquently than I can. In the context of divorce cases, a spouse cannot transfer assets and give away property without leaving proper financial support for his family or her family. This is a little fun spot I've got. If anybody wants to call out the names of the people on our fraudulent transfer all-star team, we've got, everybody knows this guy. He's got the most yards in the season of any of the fraudulent transfer all-stars. You all know the name. Anybody? Charles Ponzi. Yes, 1930s, very famous scammer. This next one is really not the fraudulent transferor, but it bears his name. John Z. DeLorean was involved in a fraudulent transfer case in New York in the 1980s. The next one, I don't know if anybody remembers this face. Anybody? Bernie Ebbers, MCI WorldCom. He was a real charmer, and I remember reading that at his trial, at the sentencing hearing, he was trying to put on a presentation of what a really good guy he was, and the testimony came in that he was giving large amounts of money to charity. Problem was, it was other people's money, so the judge really wasn't that impressed. The last one is the whale, another Bernie Madoff, who is probably that's probably the largest fraudulent transfer scheme ever. It was measured in the tens of billions of dollars. I think it came out to 13 or 14 billion that was transferred. So this is stuff that you actually see and read about in the news. As I was talking about before, most of you will use what I call type 1 collections, which is go after the person. An ad hominem collection, which is you got a recalcitrant spouse, go after them, get a contempt order entered against them. Get the judge to say, thou shalt do this, you will pay, you will produce discovery, you'll do whatever you need to do, or you're going to have to face more and more severe sanctions. The problem is, you've got people, there are a group of people for whom that does not work. They value assets as, they worship their assets. They are very greedy people. They're not honest, and they don't think that they have to comply. So therefore, what you need to do is skip past them and go after the asset. Follow the assets and hit the recipient of the asset. UFTA creditor remedies. The UFTA is a very powerful statute when used correctly. The first remedy that I wanted to talk about, and I did a little bit before, is the remedy of avoidance. You can set aside a fraudulent transfer under certain circumstances. Make the asset come back. In essence, you are going to be turning around and suing the recipient of the transferred property. Go after them. If it's a new girlfriend, a new spouse, trust me, that is not going to make your opponent particularly happy. If you represent a wife and the husband has fraudulently transferred an asset to his new trophy wife, and now she's facing a lawsuit where she could be hit for a couple $1 million, he may be sleeping on the couch. That will get you results. You can get an attachment or a provisional remedy. Attachments are something that's typically associated with collections. Under the Fraudulent Transfer Act, you can obtain any relief that you could obtain under the Attachment Act, which is part of the Code of Civil Procedure. You can get an injunction. Injunctions can be powerful weapons. They can be more powerful, as I kind of alluded to during some questions with respect to Lane's discussion. The Fraudulent Transfer Act is one of the few places where you can actually get something in the nature of an equitable attachment under the right circumstances. Be careful here, though. You will need very compelling proof, or the judges will very likely say, gee, we don't feel comfortable doing that. In an extreme case, you can get a receiver appointed to take control over property if you think it's going to leave, or if it's being otherwise dissipated. You can try and levy on the transferred asset or its proceeds if you have a judgment. Now let's talk about something that's... Oh, there's a question?
Instead of filing a lawsuit against the girlfriend who has the stock transferred to her, why wouldn't you just join her as a necessary party to the divorce proceeding and then give the judge the jurisdiction over that person? Wouldn't it be cheaper and faster? You
could do that. That has some significant advantages, and one of the advantages is that may provide you a better entitlement to fees. But when you do that, whether you sue the third-party transferee within the case or whether you do it in a separate case, you're still suing the third-party transferee. I mean, what you're talking about is essentially amending the complaint and adding a new defendant. I think that is a very viable strategy. And as I said, we'll get into this when we start talking about fees. One of the nice things about the Marriage and Dissolution of Marriage Act is that it speaks of recovering fees against other parties to the case. And if you've now made the third-party recipient of assets a party to the divorce case, you've got at least an argument that there can be a fee shift. And we'll talk about that a little bit later. But one of the things I want to get into in the next section is it's just as important when we're talking about fraudulent transfers to understand what is not a fraudulent transfer. And the typical fraudulent transfer, always have to remember, I mean, one of the great things about lecturing to matrimonial attorneys is you guys all understand the concept of an estate. That's how you have to think when you're dealing with a fraudulent transfer case. because what you're trying to consider is, did this transfer reduce the estate of the other spouse? Because if it did, and if it reduced the estate beyond the point where a dissipation claim could cure the transfer and can equalize, that's when you want to be looking into the Uniform Fraudulent Transfer Act. So paying a legitimate debt to another creditor is not a fraudulent transfer. And the reason is, if you think about this on an estate concept level, you're really doing is you're saying, I've got an opposing spouse, and they've got, for lack of better terms, a balance sheet. They've got a certain group of assets, and they've got a certain group of liabilities. And if they take one of their assets and they pay off a liability, it has no net effect on their estate. Another non-fraudulent transfer is if you buy or sell assets for a fair price. And typically that is not a fraudulent transfer because you, once again, have really not changed the balance sheet makeup. All you've done is you've changed the identity of assets. You're taking cash, and now you've got land instead of cash. I will say that there's a caveat to that, however, that there is at least one type of fraudulent transfer that we'll get into, which is a transfer that is fraudulent in law, where the acid test as to whether or not the transfer is fraudulent is whether it materially impairs the rights of the creditor. So the issue here is this something that would be more difficult to liquidate and collect? Just keep that in mind. Giving security for a new loan. And the reason this is not a fraudulent transfer, let's say we've got wife who transfers, who gives buys a new house. We all went to law school, Blackacre. So she buys Blackacre and borrows $100,000 and gives a mortgage of $100,000 on Blackacre to First National Bank. That's not a fraudulent transfer as long as she got something from the bank in return for it. If she got $100,000 of loan proceeds and now has $100,000 of cash, or if she were able to buy the house and got credit towards the purchase price of $100,000, that's not going to be a fraudulent transfer. Again, it is a balance sheet concept, and always keep that in mind. The history of the fraudulent transfer laws, this is something that is kind of nifty because it has been around for a very, very, very long time. Our current law derives from the Statute of Elizabeth, and I'm not talking about the Queen Elizabeth of today who walks around in a yellow dress. I am talking about this lady. In essence, William Shakespeare was writing Romeo and Juliet at about the same time the Statute of Elizabeth came out. Now, the UFTA, the thing to understand about it is that it is the stepchild of the U.S. Bankruptcy Code. And the reason I say that is because it is driven very heavily by definitions. And the definitions are, for the most part, cribbed completely from the U.S. Bankruptcy Code. The most important of the definitions that I'd like to talk about is probably the term claim. What is a claim? And I've got it up here on the board for everybody. A claim is simply a right to a payment. And it doesn't matter whether that right is reduced to a judgment or not. It doesn't matter if it's liquidated, unliquidated, fixed, contingent, disputed, undisputed, matured, unmatured, legal, equitable, secured, or unsecured. This is a very, very broad definition. A debtor is simply a person who is liable on a claim. A creditor is a person who owns a claim or has a claim. A debt is liability on a claim. The next important issue is, the next definition is transfer. What is a transfer? And it may surprise you that a transfer need not be a transfer of an asset. You can commit a fraudulent transfer by encumbering an asset. And here's the definition for a transfer. Every mode, direct or indirect, absolute or conditional, voluntary or involuntary, which, by the way, is where the federal judge got the involuntary transfer as potentially a fraudulent one, where the transferor, who's the debtor, parts with some interest or bundle of rights in property and gives it to a third party. The next important issue is insolvency, and this definition is so important that there's an entire section of the Fraudulent Transfer Act that relates to insolvency. What I've got up here now is the definition of insolvency, which talks about using a balance sheet approach. And the balance sheet test takes the value of the debtor's assets at fair market and the value of the debtor's liabilities at fair market and compares them. And if the assets are greater than the liabilities, he or she is solvent, or it is solvent. And entities can commit fraudulent transfers as well. If the liabilities are worth more than the assets, the debtor is insolvent. But that's really not always very helpful, because assets do not include property that's been transferred, concealed, or removed. Because a lot of times people say, "Oh no, I was fully solvent, and I'm counting what I already gave to my girlfriend. I'm counting what I've encumbered. I'm counting things that have been concealed and are not easily collectible." Those don't count. Debts do not include obligations to the extent that they're secured by a valid lien on property. The next thing that we'd like to talk about is just a practical rule, which is the insolvency presumption. And an insolvency presumption is simply this. It is not always easy when you've got somebody who's engaging in fraudulent transfers to get them to tell you anything, much less the truth. Believe me, I've tried. So one of the tests that we have to determine whether we can presume whether the debtor is solvent or insolvent is also cribbed out of the U.S. Bankruptcy Code. Is that debtor generally paying his or her debts as they come due? If not, there is a presumption that the debtor is insolvent, and you can use that. Now, there are several types of fraudulent transfers. There's two major types, and there's a minor type that I'll get into that's a third kind. The two major types are fraud in law and fraud in fact. The third, more minor type is what I like to call the insider preference frauds. And the gentleman who spoke on bankruptcy this morning kind of touched on the issue of preferences and gave a pretty good definition of them, but I'll go back into that in a little bit. Let's start with fraud in fact. Fraud in fact is one where the debtor intentionally gives away property with the specific intent of interfering with the creditor's rights. He or she or it wants to impair the creditor's rights. The debtor also cannot receive reasonably equivalent value in exchange for what the debtor gave away. And what I've got up here on the board now is pretty much all of the text of Section 5A1 of the IUFTA, which is the section that deals with fraud in fact transfers. Next issue is, as I told you before, the people who are engaging in fraudulent transfers are typically not the nicest people that you're going to deal with. In fact, I would go so far as to call them scumbags. And believe me, I deal with a lot of them. They don't tell the truth. They don't have very high regard for the rules. And if somebody is willing to flout the system and try and game the system in litigation, chances are you're not going to get them to come clean and say, you know what, counselor, I did intend to defraud your client. I did intend to impair his or her or its rights to collect, and I'm proud of that. It happens once in a while, but not very often. So what we have for fraud in fact claims is we've got something called badges of fraud. And this comes right out of that statute of Queen Elizabeth I that we were talking about that was enacted sometime in the 1570s. Now you're probably going to have to squint to read these badges of fraud. They're in the materials that I've got, and these are actually Section 5B of the Illinois Uniform Fraudulent Transfer Act, where it gives you a non-exclusive list of 11 factors the court can consider to determine whether or not a transfer was fraudulent in fact. And interestingly enough, for the most part, most fraudulent transfer litigation occurred in the U.S. bankruptcy courts, because this was typically a large part of what bankruptcy trustees would do, is they try and claw back assets and get them into the estate. That's not going to happen so much anymore. There was some litigation. It's a long story, but anybody remember the name Anna Nicole Smith? There was a case called Stern versus Marshall. Her actual legal name was Vicki Lynn Marshall, and as a result of a Supreme Court decision in that case, it doesn't look like U.S. bankruptcy courts are going to be doing the bulk of fraudulent transfer litigation anymore. But in any event, most of the bankruptcy courts would usually require 3 or 4 badges of fraud to be present in order to find fraud in fact. There were a couple of cases that went down as low as 2, but that was typically the bare minimum. The next issue is fraud in law. This is the Type 2 claim, and I had alluded to it a little bit earlier. And the test in a fraud in law claim is whether or not the transfer had the effect of hindering or impairing a creditor's ability to collect. And that is true with or without intent. There's no need to prove that the debtor intended to defraud anybody. And the interesting thing about that is when you don't have to prove intent, yes, you can get summary judgment sometimes. And I've been able to do that on a number of occasions. Just kind of joking around, you don't need no stinking badges. It's really not that funny. Insider transactions. This is the third more minor type of fraudulent transfer under the Illinois Act. This is governed by Section 6B. Just going back one step, fraud in law is governed by Sections 5A2 and 6A. There are a couple of different sections that govern it. But a 6B fraudulent transfer claim talks about payments to insiders. And the benefit of an insider fraudulent transfer claim is that you don't have to prove that you don't have to be bothered with whether or not there was consideration or anything of value given. There can be perfectly good value given, but if you're preferring a payment to an insider or a transfer to an insider, that can be unwound. The downside of an insider transaction type of a claim is you need to move quickly. You only have 1 year. That's a very short statute of limitations, and the way I read the statute, there is no tolling. The next question is a very important one, and it is another definition, which is, what does the term insider mean? And I'm going to give you three different types of insiders that are defined under the Uniform Fraudulent Transfer Act. Whether or not the recipient is an insider depends on the nature of the debtor. If the debtor is an individual, there's a definition of insider, and that's the second bullet point that's up. If the debtor is a corporation, there's a definition, and that's the third bullet point. If the debtor is a partnership, there is another definition. What's missing, anybody? How about an LLC? The UFTA does not define who an insider is with respect to a limited liability company. And I think the reason for that is mainly historical, because LLCs did not become really as popular as they are today until later in the 1990s and into the 2000s. And if you recall from what I was saying earlier, the Illinois adopted the IUFTA, and it went into effect in 1990. So the legislature just never got around to changing the statute. I would submit to you, I don't know if any of you practices in has a practice that encompasses a lot of LLC work, but there is a section of the Limited Liability Company Act that is an awful lot like a fraudulent transfer claim. And I would also submit to you that there are two types of LLCs under Illinois law. There's one called a member-managed, which is more like a partnership, and one that's a manager-managed LLC, which is more like a corporation. And I would submit to you that the definition of an insider for corporations would probably apply to a manager-managed LLC, while the partnership insider definition would probably apply to the member-managed LLCs. Having said that, I can cite to absolutely nothing to support that because there are no cases that we could find.
Andrew?
Yes,
So
ma'am.
if an LLC chooses to be taxed as a partnership because it has the option...
Can you hold the mic closer to you?
Thank you. Can an LLC, if it chooses... LLCs can be taxed as partnerships or as corporations. They can elect which they're going to do, correct?
Correct.
So if they make the election to be treated as a partnership...
I don't know that that is what drives it, because I think what's more likely to drive it is how the LLC is organized. Because a manager-managed LLC, the members are really more like shareholders. They're just like owners of the company, whereas in a member-managed LLC, they're more akin to partners because they actually each have the same rights as partners do with a partnership. They each have the right to manage and participate and be informed. Having said that, it's a completely untested issue of law in our state. Next issue is, who are the parties to a fraudulent transfer action? Obviously, if you represent the party making the claim, you're the creditor, you're the plaintiff in the fraudulent transfer claim. But the real defendant is not the judgment debtor, because remember, the point of the fraudulent transfer claim is to go after whoever's got the assets. So you will name the debtor as a party, but they're really a nominal party, and instead you are going to name the transferee as the real defendant. I also always name the transferor, and the reason is I want to get both of them before the court so that we can get everybody to be able to, we can force them to testify, we can force them to produce documents, and we can force them to be before the court. Very important, this last bullet point that I've got, which is you need to make certain always that is the party seeking relief really a creditor? And is the party who received or who transferred the property really a debtor? There's a wonderful case called AP Properties versus Goshinsky that dealt with the operation of the property tax statutes in Illinois and redemption, and they talked about how the tax buyer is not in any kind of privity with the debtor, and so it couldn't be a fraudulent transfer. Very interesting case. The next issue we get to is another important definition, which is the definition of reasonably equivalent value. And sadly, it's not defined very well. This, in my experience, is almost always the subject of a dispute. But the good news here, folks, is as members of the Illinois Bar, you are in the class of attorneys who is probably best suited to address this issue because it deals with valuation. Everybody here is going to has either done this or will have to value a business, value real estate, value other assets as part of the resolution of a divorce case. That's what you do. The factors that you consider when you're trying to compare what was transferred versus what was received are all within your wheelhouse. You take a look at the value of what was transferred. You may need to get an appraisal. You may be able to do it just by looking at publicly available information. Obviously, if cash is transferred, that's really easy to value. If it's publicly traded securities, you look at the date the securities were transferred, also very easy to value. If it's a privately held company, get a business appraiser. If it's real estate, get a real estate appraiser. You want to look at market values. You want to look at whether the transactions took place at an arm's length. The most suspicious transactions of all are always, always, always those to insiders. Somebody gives something to his kids. Somebody gives something to her brother. Somebody gives something to their parents. If you got to transfer to an insider, always view it with suspicion and always make sure that you've got some indicia of what the relative value of the asset transferred and the asset received. You also want to consider the good faith of the recipient. Is this a recipient who didn't know they were receiving something? That can matter. Is this a recipient who's up to their eyeballs in cahoots with the transferor? I would submit to you that if you can show the latter, you're going to have a lot more traction getting relief from the judge who says to you, counsel, explain the situation to me here and tell me what's going on. Now, this is one of my favorites. But my new wife agreed to support me in return of the transfer defense. I mean, just gut feeling. Anybody think that's going to work? Because I see this at least twice a year. I've got a case that I just finished up where a friend of mine represents a lady in a post-decree case. She's owed about $170,000 in permanent maintenance. It's about $3,300 a month. The husband stops paying, and this guy is a former trader, very wealthy guy, and he's smarter than any lawyer. So he buys 3 pieces of real estate. Buys a condo on Lakeshore Drive. He buys a summer home in Holland, Michigan, and he buys an estate in Sarasota, Florida. And because he's so smart and so much smarter than the rest of us, he decides that when he marries his new trophy wife, who had the perfect first name, Penny, I love that. So he marries Penny, and he decides, gee, I'm going to transfer all of these properties to her. And it was about $6 or $7 million worth of properties that he transfers to Penny. And because he's so much smarter than the rest of us, he decides that he's going to save on real estate transfer taxes. So he checks box E on the Illinois transfer deck, the exemption, which says that it's a transfer for less than $100. and he checks the same box. It's not the same statute, but it's the equivalent in Michigan and in Florida. And I get a copy of the deeds, and I say, boy, you're not so smart. And I move for summary judgment, and I was saying to the judge in my motion, gee, either he's committed real estate transfer tax fraud or a fraudulent transfer, take your pick. And after she stopped laughing, she granted summary judgment. But here's the thing. The scenario here in the "but my new wife agreed to support me," this is what the guy argued. Well, she was going to support me for the rest of my days after I gave her all these assets. And the reason this doesn't work, there are a couple of them. One, we have value. Value does not include an unperformed promise made otherwise in the ordinary course of business, of the promisor's business, to furnish the support to the debtor or another person. I mean, they saw that. And then the husband's argument should also fail because spouses are already obligated to support each other. If you're married, you have an obligation to support your husband and wife. And so what consideration was Penny really giving this guy? I've also got a couple of sites here. There's actually a criminal statute of failure to support. And there was a case that I found from long ago, before PC came into vogue, saying that payments of alimony from a husband to a wife are not based on any consideration moving from the wife to the husband, but are based on the common law duty of the husband to support the wife. Obviously, it goes both ways these days. Now, statutes of limitation. These are important, and this is something that you don't always think about as a matrimonial attorney, because obviously there's really no statute of limitations in a divorce, because as long as the parties are married, they can always move for divorce. But in a fraudulent transfer case, you need to keep this in mind. And there are 3 statutes of limitations, and only one of them has equitable tolling, or a discovery rule. The insider preference claims, 1 year, no discovery rule, as I read the statute. 4 years for fraud in law and fraud in fact, but a fraud in fact claim can be brought, you can get some extra time if the fraud were concealed. But remember, in order to prove concealment, you must prove that there was a duty to disclose, and you must prove that it was actively concealed. Here's a significant problem. What if there's a transfer of real estate? Is that ever going to be capable of discovery rule? Chances are no, because most of the time real estate, when it's transferred, the transferee takes it to the recorder's office and makes it a public record. And if it's a public record, it's pretty hard to argue that it was concealed. Tenancy by the entirety is another issue that can come up. And it usually occurs this way. Tenancy by the entirety is a manner of holding title that only husbands and wives can hold title as tenants by the entirety, and they can only do so with respect to their residence. So if you've got spouses get divorced, wife remarries, she owes husband some money based on the divorce, and you're representing the husband, the ex-husband, coming in to chase her to pay her what she owes, and she gets remarried and decides that she's rich, so she's going to transfer all of her assets into a new house that she's going to buy with her new trophy husband. Can you bring a fraudulent transfer claim? No, you cannot. And the reason is the tenancy by the entirety statute prevents it. What Illinois took away by enacting the tenancy by the entirety statute they have given you an alternative. And the alternative is that there is an implied right of action under Section 12-112 of the Code of Civil Procedure where you can try and unwind a transfer into tenancy by the entirety, but only if the transfer were made with the sole intent of defeating the creditor's claim. That is a really hard standard to prove. It has been done, but usually what happens is the recipient of the tenancy by the entirety property and the transferor spouse will argue that, well, we did this to protect it from other creditors. We did this as an estate planning device because it's got a right of survivorship. And they will try and show other reasons. So be on the lookout for that. There is another cause of action that I'll go through quickly called piercing the ownership veil. It's under Section 505B of the Marriage and Dissolution of Marriage Act, and that's in the child support section, and it creates a UFTA-like remedy against non-custodial parents who owe child support and then try and hide their assets by mixing it up with other owners. We could not find any appellate decisions, and after we're done here, since we're trying to speed through the rest of this, if anybody knows of any cases involving this section of 505B, I'd be very interested to hear about it. Transfers and fraud of marital inheritance rights. The typical fact pattern here is husband has a piece of property, puts it in a land trust, and decides to give the property away during his lifetime. Wife says, wait a second, I was supposed to get that after you died, and now you've given it to our kids or your kids by a prior marriage or somebody else. There are some funky rules on that. That's discussed in my materials. It's not really a fraudulent transfer, but it kind of sounds like one. Now let's get to something that we all want to talk about, which is attorney's fees in fraudulent transfer cases. This is an interesting area, and it is rapidly developing. We've got a lot of issues in play. One is we've got the good old American rule. Typically, each side has to pay their own way in litigation. The divorce statute provides for some fee shifting, but we've got a case called Pal versus Gudgel that came down several years ago that did not allow an intervener to recover fees, and there's some question as to how serious the courts will take that. There are other UFTA jurisdictions. Illinois has never addressed whether a party can seek attorney fee shifting under the UFTA, but remember, it's a uniform statute, so the courts are allowed to look to other UFTA jurisdictions, and I found two cases in Missouri under the Missouri Uniform Fraudulent Transfer Act that allowed fee shifting. And my view is if somebody's going to commit fraud, fraudulent transfer, and especially a fraud in fact, I want to pound them. I want to hit them for attorney's fees. I want to go after them for punitive damages. And there are 9 other American jurisdictions that allow punitive damages for fraudulent transfer claims. Secondary liability torts, this is a significant problem for attorneys, because if you assist your client, Illinois recognizes aiding and abetting by attorneys of clients that commit torts. There's a First District case called Thornwood versus Jenner and Block. That is the leading case on point. There is a bankruptcy case called In Re Restaurant Development Group. These are all discussed in my materials, but the scary thing about it is if you advise and counsel your clients and aid them to commit a fraudulent transfer, and your client doesn't have any money, and the other side is represented by a lawyer with any experience in this, you may find yourself on the other side of the V. And that's not where you want to be in litigation. You always want to be left or above it. One of my law school professors used to always say that. Illinois also recognizes civil conspiracy and in concert liability, which is under the Restatement Second of Torts at Section 414. Punitive damages, again, this is something that this is brand new to Illinois. I would argue that especially if you can prove fraud in fact, go for it. Go after the other side. Make them pay for what they've done. It is going to cost you a substantial amount of money, or your client, I should say, and it will cost you a substantial amount of time to try and prove and unwind fraudulent transfers. Do not let this occur. This is antisocial behavior. It does not belong in our court system. Finally, last slide, self-help measures. Be diligent. Stay on top of things. Stay informed about the spouse's transactions, assets, debts, and liabilities. Do not wait. Act quickly. I've told you about some statutes of limitations that may run. If you don't do what you need to do, you can lose rights for your client. I always say that in collection law and in fraudulent transfer, the key, everything rhymes with ease. Freeze it, seize it, and squeeze it. Don't be the lawyer who does this, closes the barn door and lets the horse get away. Thank you very much. If anybody's got any questions, I'll take them quickly.
Any questions?